The defendant stands before the court today with two similar charges involving two similar incidents involving two very young victims. The defendant has been convicted of and treated for these types of offenses previously, and yet here is out in the public doing the same types of behavior, and his victims are becoming younger and younger. We're asking the court to take this very seriously. I know that one of the victims has written a statement that she has provided to the court. I know that I've asked the court if the court had received that, and the court said the court had and had reviewed that. I'm asking the court to take that into significant consideration, as well as his record, and the fact that this behavior just continues to happen amongst our community, and sentence appropriately.
Stover.
Thank you, Your Honor. Both Mr. Linscott and I have had the opportunity to review the pre-sentence investigation report. In addition to that, we did receive a one-page statement regarding case 890, ending in 890. So we have reviewed that also, Your Honor. I did write that sentencing memorandum, and it is in regards to the fact that Mr. Linscott was evaluated and did have some evaluations done. Your Honor, I know that the court has reviewed that information. In regarding that, he would be a positive candidate for probation, Your Honor, and the evaluation stated that he has some insight into the factors that contributed to this particular behavior. He has identified ways that he can address this behavior in the future. He is motivated for treatment, Your Honor. I know that he's not going to be making a statement, Your Honor, today because he did do a no contest plea, but he did ask that I address the court in regards to he does recognize the pain, the anguish, the emotional distress that he's caused in this particular case. He is very remorseful for that, and he is asking that the court follow the recommendation in the report.
You're Mr. Linscott?
Yes.
Have you had an adequate opportunity to read and review the pre-sentence report?
Yes, I have, sir.
Any additions or corrections that you wish to make?
I'm sorry, sir.
Any additions or corrections that you wish to make?
No, sir.
Anything that you would like to say before sentence is imposed?
That I am sorry and remorseful to this happening, and it will never happen again.
Does that conclude your comments?
Yes, sir.
Thank you. The court had the opportunity also to review the pre-sentence report that was conducted in the Hudsonville District Court a few years ago as a result of misconduct. So in reviewing your record, it appears that you had an indecent exposure conviction in 2015. You were sentenced to probation and jail for 90 days with a 5-day review. It looks like you did the 5 days, so the balance of that jail sentence was suspended, and the discharge was termed a successful probation. In 2020, there was the conviction in Hudsonville, which I just mentioned. You got 30 days in jail. It looks like you only did 1 day in jail at that particular point in time. So the balance of the jail time was suspended. You did 12 months of probation. There was a third and a fourth incident in Hudsonville as well. They were dismissed as part of that agreement back in 2020. So we had at least 4 victims up until that point in time. Now we have 2 separate exposures here involving 2 additional victims here. So we have 6 victims over 10 years. You've completed probation. It was described as a successful completion of probation. I guess that's debatable whether it was successful or not, because apparently you didn't learn from your misconduct, didn't learn from a sanction. So in reality, probation is not successful at all. As part of that 2020 pre-sentence investigation report from Hudsonville, I also reviewed a sex risk assessment that was conducted. You were described as low risk. Obviously that was wrong. You know right from wrong. I mean, let's face it. You're mature, you're not youthful. This was done to youthful indiscretion. Low level of sanctions apparently don't work for you. This affects the quality of life for a community. It really does. So this needs to be sanctioned appropriately, especially when we have a repeat offender who in spite of very reasonable treatment by the district court, you continue to reoffend. So, okay, that's what you're going to get. In the misdemeanor file, 24-46890, this is a 1-year misdemeanor charge. That's what you were convicted of. It's 365 days in the Ottawa County Jail. You must pay state costs, crime victim costs. In file number 889, this is the felony case, the aggravated indecent exposure. It is the sentence of this court that you be placed on probation for 36 months, 180 days in jail credit for 30 days previously served. Must pay state costs, crime victim costs, and DNA fees that are required by statute. Attorney fee reimbursement of $300. The balance of the terms of probation will be on a written probation order that you will receive shortly. These are final sentences. You may file an application at the Court of Appeals regarding your conviction and sentence. If you're unable to hire an attorney, this court will appoint one to represent you at public expense. You need to fill out the paperwork you've been provided, return it within 42 days. I also note I did receive a victim impact statement, and your misconduct significantly adversely affected a member of our community, and she's entitled to be protected. That's all. Thank you.
Chairman, calling file 180.
Pardon me?
180.
890. I'm sorry, it's the other one. Yeah, you're right.
180?
Yeah.
Any time credit?
Pardon me?
Was it 30 days credit?
30 days credit on both, and they're concurrent.
Thank you, Your Honor.
That's okay. I just need you to